That's right, with Proposition 3, it can be a bit confusing at first glance, but there are three key things to keep in mind. Whether you're for it or against it, your vote could affect public safety in Texas, change how we presume innocence, and impact the state's justice system as a whole. Right now, denying bail requires a full trial, so even if there is evidence a person might re-offend, if they can post bail, they're released. I spoke with bail attorney Ken W. Good, who says there are 6 specific offenses that judges, prosecutors, and defense attorneys are most familiar with, and that denying bail on those is a decision made only under very limited circumstances.
It's not judges that can deny bail, it's the prosecutors that can request bail be denied. They have to show that there's a likelihood they will not appear for court. That has to be shown by preponderance of the evidence. And then they have to be shown by clear and convincing evidence that they're a risk to public safety. Once they meet those 2 requirements, then the court has to deny bond.
He went on to say that historically, supporters of the proposition have pointed out to cases where people accused of serious crimes were either denied bail or had bail set so high that they couldn't get out. But over time in Texas, Good says there have been instances where offenders received a slap on the wrist. He said this is a part of the reason the proposition was put on the ballot, to address those inconsistencies in how bail is handled across the state. Your vote could affect public safety in Texas, change how we presume innocence, and impact the state justice system as a whole. Currently, denying bail requires a full trial. Therefore, if a defendant has the money to post bail, they must be released if there is evidence the person may commit future and violent crimes.
There's a large body of case law that have already addressed this issue and ruled against their argument. Bail isn't about the presumption of innocence. Bail is about what assurance you're going to give the court that you're going to return to respond to the criminal charges that have been filed against you. So presumption of innocence applies at trial, not at the bail hearing.
Good says jail overcrowding is not expected to happen since the amendment is designed to target a small group of offenders, not the general jail population. Good says it's likely to pass.
Historically, bail proposals to amend the Constitution pass with very large majorities. I mean, 70, 80% support of the public. So you would anticipate that this has a high likelihood of passing. I think it probably applies on a go-forward basis. So it would apply on new crimes committed after it's been passed, and it won't apply backwards,